Hello, I'm Jeff Kremers. I'm the Chief Judge for Milwaukee County, Wisconsin, and we're going to talk about the role of procedural fairness and how we conduct our court hearings. I think we should keep in mind as we do this that what we're really trying to do is, as we work through this material, understand what we mean by the concept of procedural fairness. We want to talk about and identify the components of procedural fairness, and some people refer to it as procedural justice, so you may hear me or other people use that term. And then I also want to talk and spend a few minutes with you talking about the benefits both to the court system and to the users of the court system and the individuals who may be in your court, as well as yourself personally, from adopting and engaging in some of these concepts of procedural fairness.
My goal today is to lay out the basic idea of procedural justice and to talk about how I see that fitting into policies and practices that might be important. When we think about the goal that we imagine for the justice system, first and foremost, that goal is to provide people with justice. In addition, however, there are other goals that are important. One is to make decisions that people are actually willing to accept and abide by. And another is to retain and enhance public trust and confidence so that people view the courts as essentially entitled to exercise authority. They come to them when they have problems, and then related to that, they accept the court's resolution of those problems. Well, the question that I think I am best able to address for you is, how can we be helped in our effort to deal with adjudication and alternatives to adjudication by knowing how the public evaluates the courts? Both those members of the public who happen to be in a particular court going through some court procedure, and the public more generally when it's asked to evaluate how the courts are managing our problems. Another way to put that is, what do people want when they deal with the courts? What are they looking for? It's through research on that question that procedural justice has developed as an idea. Procedural justice in its basic formulation is fairly straightforward and not something that I imagine that anyone would really dispute. And that is that when people are dealing with some authority, like a judge or a mediator, they're not only concerned about the outcome, they're also concerned about how that person processes their problem, how they make decisions, how they treat them, and that this influences how they react to the outcome. What I think is a stronger statement that emerges from decades of research is that actually people focus more strongly on their perception that the authority they're dealing with is or is not managing their problem through fair procedures. This idea of procedural justice, I did or didn't get a fair process for my case, turns out to be more important in terms of people's willingness to accept the decisions that are made, to abide by them, to continue abiding by them over time. It's more important in their evaluation of the judge, the courts, the law, and it also has a bigger, stronger impact on people's everyday compliance with the law. Three things that we definitely do care about. Well, if you think about someone who comes to court, you could have three images of what might matter to them based upon the experience that they end up having. One is the favorability of the outcome. By the time people get to court, they're really interested in vindication. So they may be focused on whether they win or lose. Perfectly natural way to think of it. In fact, judges often say that when they make a decision, they make one friend and one enemy. And the idea is that if you win, you like the judge. If you lose, you don't like the judge. A little bit more nuanced way of looking at it is that people have a sense of what the fair outcome is or the right outcome. And so they're still interested in the outcome, but they are trying to think of it in terms of whether they get what they think they deserve. And then finally, there's this idea of procedural justice, that what people are really interested in is seeing that no matter what the outcome is, that the process through which their case is managed conforms to their sense of what's a fair way to make this decision and a fair way to run the hearing. The most important issue by an enormous amount is whether they do or do not think that the hearing was conducted through fair procedures. Now, obviously, to some extent, people are more willing to accept outcomes that are more favorable, and we see that. But what's really striking is the degree to which those outcome judgments are not the key issue that are focused on, and that overwhelmingly people in courtrooms are looking at their sense that the judge did or did not use a fair procedure. Now, in making this make sense, I think it's really important that I make clear that decision acceptance is not the same thing as happiness. I'm not saying, and the research does not say, that people are happy if they don't get what they want. They say, great, I lost, I won my case, I lost my case. In other words, they're not reacting emotionally based upon winning or losing, so much as they are reacting to their understanding that people cannot always win, they can always get what they want, and that losing is more acceptable if you're losing through a fair procedure. So the procedural justice approach minimizes the idea of winning or losing, and the idea of satisfaction or dissatisfaction with winning or losing. And it focuses on delivering gains that all parties can receive irrespective of their outcome. Someone to listen to them, to consider their story, to understand their concerns, to recognize their rights, acknowledge the importance of their needs. All of these things happen separate from the outcome.
I think if you ask any judicial officer, they're going to say, well, we should have a system that delivers fair and impartial justice. I mean, who could be against that? And many judicial officers will say, well, if you do that, that's really all you need to do. I think we also need to be concerned about whether or not our system is viewed as legitimate, whether or not it's fair and impartial. If the public, if the users don't view it as legitimate, they're not likely to follow it, and that often leads to repeat offenders coming back into our system. So one of the things I would ask you to think about is these system goals that we've listed here, how are they consistent or inconsistent with each other? It's one thing to say that we want fair and impartial justice, but is there some impediment to achieving that if what we do is focus on legitimacy?
That this is true for each of the three primary groups that were studied. That is, we're obviously concerned about the feelings of the members of minority groups because we consistently find that trust and confidence in the courts and the law is much lower in the minority community. But if we ask the question, do the members of minority groups look for different things from their experiences in court, what's interesting is that the answer is no. That is, what is it that minority groups are really looking at when they're deciding whether to accept the decisions that they get when they go to court? They're looking at procedural justice. What is it that whites look at? Procedural justice. So we don't really need to try to think of a different strategy for addressing the concerns of different ethnic groups. In fact, the concerns of different ethnic groups are very similar. Now, it is true that minority group members are more likely to report that they were not treated fairly. But the way that they think about that issue is exactly the same way that white litigants do. So there's one model fits all. The other similar point is, does it matter whether you come to court because you're bringing a problem to court, or you come to court basically because you're required to as a defendant? Again, those are different orientations towards the court, but they don't matter in terms of how people evaluate their experience in court. They're still primarily focused on the question, did I or did I not receive fair procedures? So a general finding that goes across the different kinds of experiences that people are having in court, the different kinds of people who are in court. So, and I think, again, to emphasize a very strong finding in the sense that look at how much procedural justice judgments are overwhelming any other judgment. So if we're concerned about what people want, we have a very good message from this research. They want procedural justice, and we need to understand what that means and how it could be built into the design of the courts. I've often had the experience of getting a lot of skepticism from decision makers when I present these ideas. And then I present all the data and people say, well, that's probably true, but it wouldn't actually matter if something important was at stake. So I think I want to tell you that we've made a number of efforts to try to find important things and see if people still cared about procedural justice when important things were at stake. We've looked at pretrial arbitration in commercial disputes in federal court, where up to $20 million was at stake, and found that the primary issue to people when they try to decide whether to accept pretrial mediation results is whether they think the hearing was fair, not the amount that they won or lost. We found enormous procedural justice effects in family court, where there's tremendously important issues like child custody involved. And procedural justice has been found to be very important when we're making policies about contentious issues where people have ethical or moral values at stake. Now, I don't want to overstate the case, so I'm going to give you a little bit more nuanced result from a study that was done by the state of California, where they had a much bigger sample of people who were involved in different kinds of courts. And we can look at different kinds of courts and basically make the same comparison of whether people are looking at outcomes, fairness of decisions, or fairness of procedures when they evaluate the court's system. And what's important here is that, again, for many kinds of experience, and particularly the high volume kinds of experiences that the California courts were particularly concerned about, small claims in traffic court, family court, criminal court, the same finding, overwhelming procedural justice effect on people's trust and confidence in the courts. The one nuance when we're looking at civil courts, and these civil court cases were more about commercial disputes where money was involved, issues of that type, procedural justice is still important, but fair outcome becomes more important. And then another interesting point to make is that attorneys were found to care about procedural justice, but to care more about outcomes relative to procedural justice. But certainly in a vast number of the cases that are likely to be of concern in a community court type situation, we're still seeing this dominance of procedural justice considerations. Now, I'll talk in more detail about procedural justice later, but just to give you a sense for what I'm talking about, when we do studies of people in court or mediation, we constantly find that these are the four key issues that are on their minds when they talk about being fairly or unfairly treated through the process of the disposition of their case. Two of the issues are about the quality of the decision-making, voice. Was I given an opportunity to present my evidence, to state my case before decisions were made? Neutrality. Did the decision maker make the decision based upon neutral principles, legal rules, not their own prejudices or biases? Quality of treatment. Was I treated respectfully as a person? Were my rights as a citizen respected? And finally, trustworthiness. do I believe that the decision maker sincerely tried to consider the needs and concerns of the different parties and do something that is best for those people? So 4 core elements, what people mean by a fair or an unfair procedure. Well, why should you be interested? As I've already mentioned, you should be interested because a large body of research now shows that procedural justice works, in the sense that if people feel they get those elements of fair procedure, they're much more willing to accept decisions, they have much more positive views about the legal system. But I also think that the people in this room might be particularly interested because this body of research and the line of argument that's flowing from it is very supportive of what you're doing. That is, it supports building alternatives to adjudication, and it supports approaches that try to promote community involvement and try to focus more on what the community wants, how the community is experiencing legal procedures. Well, let me start with just one example showing that this argument that I'm making about procedural justice works. I'll use an example study from 2 cities in California, Oakland and Los Angeles. It's a study of the acceptance of decisions made by judges in courts. People could either have gone to court because they wanted help, or they could have been required to come. And it's deliberately designed to identify and sample 3 major ethnic groups: whites, Hispanics, and African Americans. And if they got those degrees, then they would realize that people also are concerned about interpersonal issues. And that's consistently what we find, that people react to whether they're treated with dignity and respect, whether they see that their rights are respected. People react to whether they're treated with dignity and respect, whether they see that their rights are respected, whether they believe the authorities care about their needs and concerns, and whether they think that they're being listened to and having what they say considered by decision makers. Well, voice is the first. People want an opportunity to tell their side of the story in their own words. This is fairly straightforward. I think that the case management implications are also pretty straightforward. What we need is we need for people to have forums where they can tell their side of the story. This is one of the reasons that mediation is so popular. People feel that they can speak. And ironically, we actually find that criminal defendants rate plea bargaining as a fairer procedure than a trial, because they say that in plea bargaining, they're actually asked what they think should happen. They get to talk about what they would think the right sentence would be, so they get voice. Neutrality, people come to the courts because they respect judges as neutral, principled decision makers. And I think an important point that I would make is that they're usually right, that judges usually are making their decisions in neutral, principled ways, but they often don't provide the information that allows people to actually know that. That is, it's not enough to just be doing that, it's also important that people understand that you're doing that. And that's why giving people information is so important, so that people see how you're making decisions, how you're evaluating evidence, explaining what's going on, explaining legal rules, providing information about procedures so that people are not confused. We've heard about help desks, that's one example. But basically, people need to see that decisions are being made neutrally. Respect, this is something that's very much of concern to people who have come before authorities, that their concerns are taken seriously, that they're being treated with respect, that their rights are acknowledged. So we need to train everyone involved to try to think about whether they're treating the public with courtesy, with politeness. Now, I've found that, particularly among the police, if you talk about a customer service model, you get lots of very negative looks. And so I would emphasize that I'm not saying that courts are stores. It's not that you're clerks and it's your job to be nice to the customers. But people are entitled to feel that they're being taken seriously. that their complaints, their claims are being taken seriously, that they're being taken seriously. And so it's important to explain to people what their rights are, to acknowledge their rights, and to acknowledge things such as the right to complain. One of the interesting findings that I've seen from research is if you tell people that they have the right to complain and you make it easy for them to do that, like give them a letter, here's how to complain, people usually don't complain. They're very comfortable with the idea that they have the right to complain and that they know how to do it, and that seems to eliminate a lot of the anxiety that might actually lead someone to complain. And finally, trust. What do people really care about when they deal with an authority? They want to believe that that authority is sincere and caring, that that authority is trying to listen to them, trying to understand the issues, trying to do what's right for the people involved in the situation, and acting in the interests of the parties, not their own interests. And again, this is probably often true, but how can people be made to see that? What we need to do is we need to communicate to people that they have been listened to. Obviously, giving them a chance to speak is important to showing them they're being listened to, but also acknowledging what they say so that they know that they have been listened to, and acknowledging that you considered what they said when you made a decision, even if you didn't do what they asked. People constantly report frustration over things like, I'm telling my story and the judge is signing papers, which seem to them to suggest that the judge is not considering what they're saying, not taking it seriously. They get upset when they feel that 5 seconds after the trial seems to be over, the judge issues a decision, seeming to have not considered the case very seriously. Decision makers can communicate their motivations by explaining how they've considered arguments, why they're making the decision that they're making, and obviously, if necessary, explaining how they're following rules.
Respect is a critical factor, I think, in this process. It doesn't, and it's a different concept than like. I don't have to like the defendant who's in front of me, and I don't need the defendant to like me. This is not about making friends. I mean, some of these people have committed very, very serious and heinous offenses. But that doesn't mean that they're not entitled to be treated with respect. It doesn't matter what they're charged with, how heinous the crime is. It doesn't matter what their background is, what their primary language is, what their religion is, what their style of dress is. They still need to be treated with respect. People who are given a voice, even where they're told that what they say won't make any difference in the outcome, will feel like the outcome is fair. It's why whenever I sentence a defendant, after they've had their right of allocution, I will find some way to use their words in the sentence that I impose. So if they talk about their motivation or the problems that led them into committing this crime, I will work that into my sentencing decision and try and structure a sentence that incorporates through their own words in the hopes that that will be perceived by them as more fair than if I didn't do that. The participants need to understand the process and what's expected of them. And so that's critical that they be given that information. And this is one where I think we probably have to do it over and over and over again. Remember that many people in criminal cases, when they come to court, are under a great deal of stress. Some of them, to be sure, may be people who've been through the system a number of times and they present specific challenges of their own. But many are there for the first time and they have no idea what to expect. And in fact, their expectations are probably based on watching too many episodes of Law and Order or some television show like that, which of course we all know is about as far from the reality as one could get. But nonetheless, that still is and still frames their expectation of what's going to happen in court. Do they feel like they are being treated the same as any other defendant who comes in front of you without regard to their racial background, their socioeconomic status, their religious background, The fact that they're a repeat offender or any other member of any other population of defendants that comes in front of you. If they really feel that way, then we've achieved our goal of neutrality. They have to perceive that the court system is neutral. Notice I didn't say that the judge is neutral. While certainly that's critical, they have to perceive that the entire court system is neutral from the very first person they come in contact with. So whether that's the bailiff checking them in, or court staff, or the jailer, everybody has to portray that same sense that, listen, you're going to get your day in court, you're going to get a fair hearing from this judge.
I'll give just two really simple examples. First is of the police and second of the courts. There's a wonderful study that was done in Australia. In Australia, the police do many more random roadblocks, stopping people for potential drunk driving. In this particular study, people were randomly assigned to receive a procedural justice message or the normal message, which I guess wasn't very procedurally just. This new enhanced procedural justice message was 2 to 5 minutes. It included the police officer explaining the purpose of the stop, the reason for the policy, asking for input from the person stopped if they had any advice about how the police could police the community, and showing respect for the motorist by saying something nice to them, like, what a nice clean car, or thank you for keeping your seatbelt on. In other words, trying to do something respectful in the context of this traffic stop. 2 to 5 minutes, and it was found afterwards a significant positive effect of legitimacy of the police, support for police in the community, and the willingness to go out and work with the police to police the community. All went up. Similar study that Kevin Burke, a judge in Hennepin County, did in courts, where randomly assigned judges, when they're making a decision and delivering it, are told to just stop and spend 3 to 5 minutes explaining to the person what the decision is, why they made the decision, how it reflects legal rules, and how they are paying attention to the person's concerns, even if they can't give them what they want. Again, a very brief intervention, but higher satisfaction, and I think more important to us, higher acceptance of the decision. People didn't come back into court as much. So both an attitudinal and a behavioral effect.
So why should we do this? Why should we really care about it? What's in it for you? Well, if we care about our orders being complied with, if we care about reducing violations and revocations and bench warrants, all of which, by the way, take more time, then we should care about procedural justice. It has been shown to, and I fully support the notion that it reduces recidivism. It increases public trust and confidence, and the next time you want to go out and develop some new court program or get expanded resources for something in your community, the sense of trust and confidence that the public has, that you've built up in the public with respect to the way you operate the court system can go a long way to resolving any concerns they may have. It results in improved staff satisfaction, and the happier your staff is, the happier everybody else is. I think any judge would say, I want to be thought of as a fair judge. Maybe fair and firm, but fair is always in that sentence. And so these kinds of practices that we've been talking about, I think will go a long way towards establishing that kind of reputation for you, and will help you keep your job. This doesn't cost any money to be, as my mother used to say, it doesn't cost anything to be nice, and it doesn't. So it doesn't require bringing in new staff. It doesn't require to go to a lot of expensive training. These are really fundamental principles of human interaction that we should all be practicing all the time, everywhere in our life. It requires some additional challenges, to be sure, and some extra things to think about in the court, but for the most part, they don't cost a lot of money. I think the most significant complaint I get about this notion from judges who say, look, this just takes a lot more time. I've got a docket of 100 cases a day, or fill in the blank, however many cases you have, and if I slow down to follow and practice all of these ideas in every case, I'd never get through the day. My response is that most of these things we've been talking about really don't take a lot of extra time. If you put a camera on yourself and watch yourself doing this, you'll find that it's not so much changing the length of time, but it's changing what you say and how you say it. So using plain English, making eye contact, these are some basic principles that don't take any extra time.
It's been said, David Weisberg said, although I think he was talking about research funding, I think it's also true of court funding, we don't have any money. Every group I talk to, I'm always told before I talk, we don't have any money. So don't propose anything that costs anything because we can't afford it. And what I would say is interesting about this time we're in now is these are the kinds of changes that can be made in a system that doesn't have much money. And in fact, they free up money. If you increase decision acceptance, people don't come back so much, you have extra resources. If people are not as upset and they're not taxing the staff, you have extra resources created. Now, I would like to say that from my point of view, I think that these changes should be enacted because I think they make for a better court system. I think a court system that's responsive to the public is doing a better job of delivering justice, but I'm not ashamed to make the argument that this might be a particularly useful kind of change to make when we're in an era of austerity. Now, how could we secure the gains of procedural justice? I think we can pretty straightforwardly talk about redesign of the court system. One thing that I think is very important is that ideally we would treat people's entire experience with the criminal justice system or with the courts, if they're civil courts, as one long experience where we would hope procedural justice would be important at all stages. We certainly know that there's a big impact of how the police treat people. These procedural justice findings are very important in studies of whether people resist the police or accept their decisions. When people get to the courts, they deal with bailiffs, they deal with staff, they deal with help desks, and we know that all of those experiences matter. People also deal with a judge or mediator, that matters. And then they deal with, if they have corrections involved, they deal with corrections officials, and that matters. So we'd ideally design a system where all of these different authorities cared about procedural justice. So we would have a system-level model.
When I have people in front of me, I try and keep in mind that it's not just the relationship between the defendant and me. It's also about the lawyers and their perception of the court system, because they're part of the court system and can be blamed for it or congratulated for a system well run. But it's also everybody else in that courtroom or everybody else who may hear about the case, either by word of mouth or through the media. And I think we do ourselves a great service when we treat everybody with respect. That means addressing defendants as individuals and not as part of a group, not as one of those people, you people, that kind of terminology, I think, can get us into a lot of trouble. So it's recognizing each person for their individuality, punishing them for their actions, but treating them with respect. Judges, I think, also have to be mindful of the fact that they are responsible for the way that their staff interacts with the public. So in a lot of courts, judges are back in chambers. They come out when the case is ready to be called. Are you aware of, do you think about what's going on in that courtroom before you walk out there? And that's why I think it's very important for judges to check in with their staff on a regular basis. Be aware of what's going on in the courtroom and make sure that their staff has the tools, has the resources to send the proper message, because they are, in many respects, the face of your court system. This can be a real challenge, this issue of respect and neutrality and understanding. We have people come in front of us who don't want to be there. There's an awful lot of unhappy, angry people in the courthouses in the United States. Many of them aren't there because they want to be there, especially victims never chose to be there. Defendants at least had a choice, many of them, in the actions they engaged in. But at the end of the day, we have a lot of people who don't want to be in our courtrooms. And I think it is a real challenge for our staff and for us, frankly, to maintain a balanced demeanor and show respect to everybody, no matter what kind of attitude they came into the courtroom with. We can set the tone, we can set the dialogue, we can control the discussion on this, and we can be leaders in our community in developing procedures and practices that enhance procedural fairness.
Research shows that across the arc of the criminal justice system, procedural justice is helpful. Procedural justice in prisons significantly reduces violence in those prisons. When people experience procedural justice upon re-entry, it lowers the rate of recidivism. So even among a group of serious criminals, we're seeing big effects. So we do live in an era of scarce resources. And this is the kind of initiative that can address a lot of the concerns in the court system without calling upon the government for massive allocations of resources. It's something that we can do just because we decide it's the right thing to do.